This presentation will discuss the intersection between bullying and harassment and federal civil rights laws. Some student misconduct that falls under our Iowa's anti-bullying policy may also trigger responsibilities under one or more of the federal anti-discrimination laws. According to Thomas E. Perez, Assistant Attorney General for the Civil Rights Division, all students have a right to go to school without fearing harassment from their peers, and schools have a responsibility to ensure that students can exercise that right. Let's talk about what peer harassment is. It's any unwelcome conduct such as verbal abuse, name-calling, epithets, and slurs. Harassment does not have to include intent to harm, be directed at a specific target, or involve repeated incidents. School districts must be aware that a school that fails to respond appropriately to harassment may be violating one or more federal civil rights laws, including Title VI, Title IX, and Section 504 and Americans with Disabilities Act. What is harassment versus bullying? The specific label used does not determine whether discriminatory conduct occurred. Rather, the nature of the conduct itself must be assessed for civil rights implications. Let's discuss each type of harassment in more detail. Harassment based on race and national origin is any unwelcome conduct based on race, color, or national origin. The next type of harassment is sexual harassment. This is any unwelcome conduct of a sexual nature. Nationally, 81% of students in grades 8 to 11 experience some form of sexual harassment. Gender-based harassment may include acts of verbal, nonverbal, or physical aggression, intimidation, or hostility based on sex or sex stereotyping, may be based on a student's failure to conform to stereotypical notions of how boys or girls are expected to act. Sex versus sexual orientation. Title IX does not prohibit discrimination based solely on sexual orientation, but it does protect all students, including students who are lesbian, gay, bisexual, or transgender, or perceived to be LGBT, from sexual-based harassment. Iowa law does prohibit this discrimination. Disability harassment is any unwelcome conduct based on disability. Examples can include name-calling, blocking access to students with mobility impairments, and belittling a student for using aids and services. When looking at legal standards for hostile environment, one might consider when harassment may create a hostile environment when the conduct is sufficiently serious that it interferes with or limits a student's ability to participate. Remember, kids don't violate civil rights laws. Schools violate them if they do not adequately respond to peer harassment. Two other legal standards to keep in mind are the possible effects on students and school climate and the possible sources of notice to the school. Under possible effects, we see decreased academic performance or increased absenteeism. Possible sources of notice may include a student informing a teacher, counselor, or school administrator. What are schools' responsibilities under federal civil rights laws? First is to have immediate and appropriate action to investigate or otherwise determine what happened, and the inquiry must be prompt, thorough, and impartial. An inquiry should be conducted regardless of whether a student has complained. When an investigation reveals that harassment has occurred, a school should take steps reasonably calculated to end the harassment, eliminate any hostile environment, protect harassment from reoccurring, and prevent retaliation. Every school district in the United States is required to have an equity coordinator who is responsible to prevent, investigate, and address harassment. The important thing is that the school must be an active participant in responding and should take reasonable steps when crafting remedies to minimize burdens on the targeted students. Possible responses include discipline of the harassers, limiting interaction between harassers and the target, providing counseling to harassed students or harassers, provide harassed student with an additional opportunity to obtain a benefit that was denied, or provide services to a student who is denied a benefit. When thinking about possible responses, remember to look beyond simply disciplining the perpetrators. In addition to the responses listed here, consider hosting class discussions about harassment based on race, gender, or disability, and sensitivity to students of all backgrounds. Here are some questions to ask about your school. Do grievance procedures apply to harassment? Are the time frames reasonably prompt and consistently followed? And do equity coordinators in the school community understand what kind of conduct constitutes prohibited harassment? Does the school have a means of recognizing possible patterns of discrimination and identifying any systemic problems in the school's response? Is there a need for training or a school climate survey? In this presentation, we have described the definition of discriminatory harassment, examples of harassment, legal standards, appropriate school responses. Look for the Office for Civil Rights Dear Colleague letter of October 26, 2010 on the Equity Education webpage of the Iowa Department of Education website.